Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. This is part 2 of our series on ethics concerning real estate brokers. If you missed any part of Part 1, it's available over the internet as a free podcast at nccradio.org. Lawyers can also qualify for CLE by listening to the program and just listen for the code at the end of the show. Our guest is Andrew M. Lieb. He's an attorney primarily involved with real estate and real estate litigation, but he also trains brokers to meet their certification and their mandatory CLE requirements, or the CE requirements. Andrew, welcome back to Law You Should Know, and you're the expert on anything to do with brokers. So we covered a lot of stuff in the part 1 of the show, and the next issue is when brokers have to explain their duty and who they represent to both sellers and buyers, and about their duty of loyalty.
So this is the most interesting time in the history of brokerage. Well, 1991 is when agency came about, but there's a class action lawsuit going on right now from a friend of mine, and they're suing Houlihan Lawrence, which is the biggest brokerage company in Westchester. And there's a motion dismiss decision, so as attorneys know, it's not based on the substance of the case and everything else, and we don't know what we're going to read from it. But there's this thing called an agency disclosure form, and what the judge basically said, in paraphrasing, is, I don't know if the agency disclosure form is enough if brokers are going to ask you to waive conflicts of interest. She asked me about disclosing, and brokers, unlike attorneys, are allowed to function in a transaction with waived conflict of interest. And there's a form by the Department of State called the disclosure form for buyer and seller, disclosure form for landlord and tenant.
Now, the conflict might be if they're selling a couple houses on the same block, and which one do they show to the buyers?
So that actually isn't a conflict, and that was resolved by the Court of Appeals in a case called Treader.
Okay,
and
just very briefly, what would a conflict be?
Conflict would be that I represent the seller and I represent the buyer. Seller wants the highest price. Buyer wants the lowest price. Can't get the highest price than the lowest price.
So brokers for the buyer is a relatively new development where a broker works for the buyer?
So there's a confusion about commission and agency. So commission, you can procure a buyer that you don't represent, or you could procure a buyer that you do represent. When you represent a buyer, in simplest terms, it's called a buyer's agent. When you represent the seller, it's called a seller's agent. When you represent both the seller and the buyer, you can't be a seller's agent and a buyer's agent.
Right, so your duty then is usually to the seller.
It's not.
It's not.
And that's what I'm saying. So you can be a seller's agent with a self-represented buyer, but you could also have a conflict of interest waived, which is called a dual agency.
So there's no buyer's broker involved
and
there.
No seller's broker involved there. It's a dual agent. It's more like a mediator.
Is that usually what's going to happen?
So if one broker is going to get both sides of the commission, that's called a direct deal. Listing agent and selling agent. Selling agent means they procured. Listing agent means they got the listing. Most brokers want direct deals. I'm not telling you they're going to get them, but you can represent a direct deal two ways. Seller's agent with self-represented buyer, or dual agent.
And do most brokers have a duty to share the listing within their office?
So every broker would have to share it within their office, because you actually don't hire the salesperson or the associate real estate broker. You hire the brokerage firm. So you'd hire the company itself. Even though you think you're hiring Tommy Smith, for example, you're hiring Douglas Elliman Real Estate.
Okay. What about the next step? A potential buyer walks into a broker's office and wants to look at different houses in a certain price range. Does the real estate broker can they tell them what houses they can afford or not? Does the real estate broker have a duty to show them whatever houses they want to see, or be blind in recommending recommending different houses to look at to them?
Well, the broker should definitely not tell a Polish person to move to Polish Town in Riverhead, because that would be considered steering, and that would be a discriminatory status.
Can discriminate by income.
So there's a brand new law in New York State, although Nassau and Suffolk have had county laws on this already, that's called source of income discrimination. You're allowed to discriminate on amount of income. You're not allowed to discriminate on the source of income. So a broker could say, you have $500,000, I'm not showing you a $700,000 house. But a broker can't say, you have $500,000 because you work at Planned Parenthood and I'm pro-life and I think you're a baby killer, so I'm not showing you the $700,000 house. That's source of income. Source is different than amount.
Okay, let's skip down a little bit. But at that point, there's a meeting. The buyer makes some, regardless of how they came to be, the buyer makes an offer. Let's say it's below 20% below the listing price. Does the broker have a duty to convey it to the seller?
So when you say the broker, I'm imagining you're speaking of the seller's agent in this story.
Yes.
And so the seller's agent has a duty of accountability and a duty of full disclosure, which are both in Real Property Law 443. And based on accountability and full disclosure, they have to disclose it. That being said, the seller's agent also has a duty of obedience. So if they had a prior direction, don't show me any offers under 10%, they would be disobedient to present that offer. So it all depends on what the direction of the seller was before.
And they could disclose that alleged order to or limitation to the buyer?
They don't have to disclose it to the buyer. Although, if we go back to that Realtor thing, the MLS rules say that if you're one agent's giving another agent an offer and they don't believe that the listing agent, the seller's agent, is conveying the offer, they can have it required to be signed in writing by the seller, which gets around that obedience thing.
So the other scenario is there is a buyer's broker. They would the buyer's broker would convey that offer for the buyer to the seller's broker?
Correct. There's a thing in 1991 CR 175.24, and I want to say subsection C. And what that says is that the seller on negotiated offers, if it's an MLS listing, the seller can have the person from the buyer present the offer rather than their own agent present it. But it has to have already been negotiated in the past tense with the D before it.
So if the broker doesn't want to present that offer or it violates the terms of their assignment, the buyer can try to convey it directly to the seller?
Not by New York State, but potentially by contractual rules through MLS rules.
Can they slip it in the door?
So the broker certainly can't, because that's a violation of 175.8 for having direct negotiation with someone that you know that has a relationship with another broker. So the broker can't, but just like as attorneys, we can't control what our clients do.
No, but if the broker says, I can't present that offer, it's lower than what the seller said as a minimum, can the buyer directly convey the offer to the seller?
Yeah, I understood your question. So I think it depends if the buyer's agent who said they can't do it is directing that conduct or not. The buyer has no limitation whatsoever, but if you can't do something ethically and you're on the committee of professional ethics, if you have someone else do it for you, that's a no-no.
But the buyer can do what they want
on their
directly.
own, yeah.
There's no ethics for them except to make sure their funds are good.
I would just advise a broker to have a writing telling their client that they can't tell them that to do that, because you do know that when everything comes apart, that buyer's going to say, my broker told me to do it.
Okay. And let's move on. So there's a meeting in the minds about the price. The selling broker may present the buyer with some type of binder, or maybe it has another name. What should the seller do at that point?
So in the real estate license law, they actually have a glossary of real estate terms, and they define a binder differently than attorneys define it. You and I define a binder as like a memo of sale. A binder under the license law means that it's an agreement for a pre-deposit before a contract. So I don't think that's what we're talking about. I think we're talking more like a memo. And LIBOR, Long Island Board of Realtors and the MLS, give what's called a sales agreement. And I'm going to give the best warning I can give to the public. Please hear me. Brokers, please hear me. Do not sign the sales agreement. It can be a binding contract.
Unless you have your attorney review it.
Before you do it. And that being said, no attorney is going to allow you to sign it, because a contract to sale is something like 40 pages. This is one page, and it could be a binding contract.
And it might be binding on the buyer and also on the seller.
100%, because what it says in the standard sales agreement is if an attorney doesn't disapprove within 3 business days, it's binding. And that could be a binding contract.
And there's pressure on both parties.
Especially when the buyer's attorney's not around.
And some people say go write the contract, or some buyer's attorneys might say that.
In what sense? Like that they
No, they don't like a binder. They want a full-scale contract they can review.
So my suggestion overall is I'm fine with the binder. I'm fine with the sales agreement. It just should be unsigned. And then we should use that as a memo for the buyer's attorney and the seller's attorney to go to contract, seller's attorney drafting first.
So you want to add in there, if you're a buyer, you want it in there somewhere very clearly, subject to approval by my attorney?
So that would be lovely. Or don't sign it. Or just write, this is not binding.
Okay.
One or the other. I would just say don't sign it. Because there's no advantage of signing it. I've never met a buyer in the state of New York that wants a one-page contract to sale.
Okay. Let's backtrack a few seconds. Let's say the seller doesn't want to accept the initial offer of the buyer. Can they make a counteroffer through their broker?
So in the state of New York, you don't have a binding contract for a sale of property based on the statute of frauds unless the party to be charged signs it, and our contracts of sale usually say both. So you can go back and forth in negotiating and keep making additional offers.
And that's perfectly kosher.
But it's like pastrami on rye.
Okay. Is there any other duty there in the negotiations, duty of the real estate broker, other than what you mentioned before?
So there's 6 fiduciary duties overall, and there's confidentiality, obedience, loyalty, accountability, full disclosure, and reasonable care. Those are the duties in 443 for your client. But I think the main thing that you got to do is you got to deal honestly, fairly, in good faith with the other party. And you have to disclose, if you're the listing agent, all facts you know that materially affect the value or desirability of the property. And if you're the buyer's agent, you have to disclose the buyer's ability or willingness to close on the deal.
Now, once there's a contract signed or some type of agreement signed, does the ability of the broker to market it to other people signed?
Done. Right there.
So they can't start soliciting it to other people once there's some kind of something in writing.
In fact, a broker can't be ever. And when you say something in writing, if there's a binding contract.
Yes.
So if there's a binding contract, the brokers go, I'm looking for backup offers, are actually breaking their license duty. Why? Because they have a duty to report on the accountability before, and if a broker seeks to substitute a deal for a new deal, that's a violation of the license law.
Now, what if while they're in the negotiation stage, before a contract is signed, can the broker say to the buyer, there's been a better offer, if you match it, they'll sell it to you, when in fact there is no better offer?
No, because that would be violating 443's duty to deal honestly, fairly, and in good faith. Now, what they could say is, my clients are thinking they might want to have a higher offer, and they're contemplating whether they're going to go into contract. Because that's true.
That's just a theoretical.
So one is puffery, one's a false statement. Puffery is not illegal, false statements are. So brokers have to be very careful about outright lies. That's a violation of the law, and you can get both a libel or ethics violation and Department of State license law violation.
And even the buyer would have a grievance.
When you say the buyer would have a grievance, the buyer would be upset. The buyer
what
probably
if the buyer matched that false offer?
Yeah.
Could they look to the broker for that difference?
It'd be a really challenging case. My mother always said, just because you can doesn't mean you should. Okay. And I think as attorneys, and I'd love to come back and just do a show on this, our clients say to us, can I do this? And as attorneys, we need to tell them, even though you can, you're going to spend $20
it may
to
not
get $10.
Be worth it, right?
It's not cost effective.
Okay. This concludes this portion of part 2. We'll cover the rest of the transaction and the ethics concerning real estate brokers in the final segment in this program. You're listening to the voice of Nassau Community College on 90.3 WHPC, and also over the internet or podcast at nccradio.org. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, who wants you to know about ADR, Alternate Dispute Resolution, which can help you avoid costly, lengthy, and uncertain litigation in court. By resolving disputes through mediation or arbitration, it gives you control over who decides your case. A mediator helps all parties to reach an agreement they can live with, or an arbitrator selected by the parties hears and decides the case. Your attorney can still represent you, but you control who decides your case. ADR is faster faster and less stressful than fighting in court, and it is a great way to resolve divorce, employment, or commercial disputes. ADR is now offered through the Nassau County Bar Association. Find out more about how ADR can help resolve your dispute by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. This is the final segment of our series on ethics concerning real estate brokers, directed at the public, real estate brokers, and also for attorneys who can earn CLE credit by writing down the code at the end of the show and then applying to the Nassau Academy of Law at 516-747-4070 or nassaubar.org. Just write down the code at the end of the program. And our guest is Andrew M. Lieb, who does extensive work in real estate, including real estate litigation, and also provides training to brokers in meeting their original training requirements and also their annual updates.
I also defend a lot of these ethics complaints you were talking about.
Right, and hopefully there'll be time we'll talk about where people can make an ethics complaint. If there are issues about, surveys, COs, mortgage problems, does the broker have any obligation, or it's like a voluntary action, help on their part to facilitate the deal?
So it depends which broker it is again. So if it's a seller's agent and we're dealing with surveying issues and everything else, they have a duty of reasonable care to assist the attorney and go through all that stuff. If it's the buyer's agent, they'd have a duty for mortgages. But let's bring it to full circle. The attorney really has to be careful who they're telling which issue to.
But is there any problem the real estate broker saying to the buyer, I can help you get financing?
If the real estate broker is the seller's agent, I would say the buyer would be a fool to be taking that help, because if they ever want to leverage the mortgage contingency clause to get out, that person may now know.
Okay. But if they had problems through their potential lenders, the broker might be able to find a lender.
Referrals are no big deal. I think getting involved in the nuts and bolts is what that should become.
Or certainly requiring it, or take what they offer to do with a grain of salt, because they might make an additional fee on that.
So there's issues in RESPA and stuff like that when you require services and all that jazz, but referrals are all awesome.
When does the broker's duty end?
It's a terrific question, because I've been asking, you can ask opinion letters. It's a big part of my practice. We ask the Department of State for guidance. It's a formal opinion letter, and we write them all the time. And I actually just asked this question to the Department of State, and this guy, Dave Mossberg, who is a wonderful help. You know what he said? I have no idea.
Okay. In general, as an expert about real estate law and brokers, what would you say to the broker about when their duty ends?
Never. Okay. So the answer is that the passage of time is not able to tell us when the duty ends. So the best answer as an expert on this topic and what I train brokers is get a writing that says the duty ends.
Would it generally be after the closing and after the property is closed?
Because you still have... So if I was dealing with a seller and then that seller becomes a buyer, I still know their negotiation strategies and everything else. And I know about them. And if I was to be adverse to them in the future, just like an attorney, it depends if it's substantially relevant.
Is it good for a seller to use the same broker to sell one property and buy another one?
Like, it works for me.
Okay. Anything else in terms of ethics, in terms of the buyer securing financing?
So going back to the prior conversation about securing financing, I think it depends on what type of offer it is. I think a lot of buyers don't understand whether it's contingent or not contingent. So when you say securing financing, it depends if the finance is contingent on the deal or just for good loan value ratios.
And just going back to the sales process, does the seller's broker, assuming it's on the multiple listing, do they have a duty to make the property available to other brokers?
100%. There's tons of ethics rules about that. They don't have a duty to share commission. They have a duty to show, regardless if it's on MLS. If it's a pocket listing and I call you up and say, I want to see it, if you don't show it to me, that's a license law violation.
Okay. And usually brokers might be flexible if this is going to facilitate the sale of the property, and they'll cut the other broker in?
When you say flexible, you're talking about sharing the commission?
Yes.
So traditionally, brokers understand that inventory turnover rate is the number one predictor of money making for a broker, not doing direct deals. So they'll cut anyone in as long as they get a buyer.
Because if there's no buyer, no one makes any money.
Not only does no one make any money, it costs them a lot more money. They're advertising more, they're playing therapists more, they're doing more free open houses. The quicker you get in, the quicker you add out.
And also the listing may expire.
You got it.
Let's say there's negotiations over price or there's problems with financing. It's not unethical for the buyer or seller to suggest to the broker they lower their commission from whatever's in this commission listing?
Not only is it unethical, it's very favorably looked upon.
And sometimes it becomes a win-win situation if that will make the deal close.
It's more of a win than it not closing.
But it can't hurt to ask.
I think you should always ask everything. I think the only limitation on this, and we haven't got really into it, is the difference between an attorney's confidentiality and a broker's confidentiality, and it depends who's asking.
Okay. And when the listing expires, is the broker entitled to any commission?
And it didn't get sold?
It did not get sold.
Nothing, bupkis.
Could there be a possibility if that's a buyer who came earlier and they couldn't agree on the price, came back later and was the buyer of the property?
So that's called a tail. It's a standard thing in agreements. The standard LIBOR agreement says that if the seller hired someone else in good faith, it expunges the sale. Some brokers have changed that, but there's a tail list that usually has to be sent in a tail period. So it's not forever. It might be 30 days, 60 days, 90 days. They should have their attorney review that tail period.
So if a buyer has to change a heart a year later and the property hasn't sold, they could try to deal with the seller directly, or vice versa?
It's possible. So in the second department, unlike the first department, we don't have just procuring cause. We have amicable atmosphere in which the chain of circumstances developed into the procuring cause. And in English, it's possible the broker could still make a claim if a deal fell apart and the same deal happened later and the broker is basically saying, I was cut out and that's why you're doing the deal. I'm still entitled.
And then
we make that claim.
And then, but the buyer and seller would want to work out in some kind of post-closing agreement who's responsible for the commission in case it becomes an issue.
Well, it's not a post-closing agreement. It's in the contract of sale. There's an indemnification clause in a standard contract of sale of who's responsible. But I'll just make it in simple terms. If it smells like the prior deal, it is the prior deal. If it's completely different in terms of time, amount of money, terms, it's not.
And it's best not to play games to try to chip a broker off a commission.
When you say it's best not to play games, attorneys are supposed to, unlike brokers, advise our clients when it's good to break a contract. So sometimes it is good to play games. Sometimes it's not. It's just a strategy. For your standard Nassau County resident, it's a bad idea. For your very wealthy business person, sometimes you play games. Sometimes it's a good move. That's what litigators are all about. Okay. I like litigation.
And it defends it. There's enough money where they want to be able to defend it. It makes it worthwhile for them to defend a suit.
And it depends if they have a house counsel on staff and how happy they're about lawsuits. Some people like to play games.
If someone does have a problem, it appears that the brokers may not have complied with some of the standards you mentioned, whether they're buyer or seller or someone else or a potential buyer. Who can they address that complaint to before litigation?
I just want to address something so the listeners are clear. Just like attorneys, malpractice and ethics violations are two different things. You can commit an ethics violation and not commit malpractice, meaning that if a consumer makes a complaint about a broker, it doesn't mean the consumer is getting anything. The broker could be 100% ethical violation, consumer gets bupkis. There's two places to go, Department of State, LIBOR.
And what kind of malpractice would there be by a broker?
So what brokers have is E&O coverage, so it's not malpractice, errors and omissions, but same concept. What happens is that they say, hey, in their listing, they put up, this house was original Frank Lloyd Wright, and they misrepresent it. They could get sued for that. They get sued for all sorts of things.
Even after the closing.
So they get sued for all sorts of things. They get sued for fiduciary duty breaches. You told confidentiality. I knew that you'd go down $100,000. I told the other side. Usually malpractice issues involve agency problems, like agency disclosure issues.
And sometimes there are suits between brokers.
All the time.
And even between some other broker in that some other broker in the office might feel they're entitled to a bigger piece?
So those are usually independent contractor lawsuits, and most companies, the bigger ones at least, have internal arbitration protocols. So we use alternative dispute resolution when we're dealing with independent contractors as much as humanly possible.
Okay. Are there any other types of complaints that might be against brokers that you haven't covered already?
There's infinite amounts, but there's something I haven't covered that I just want to make sure everyone knows, because it's an ethics rule for attorneys, and this is attorneys CLE. Attorneys cannot share the contract of sale with brokers absent their client's permission. And that's an ethics rule from this year that came out.
And that's the contract of sale for the property?
That's the contract of sale for the property, or the lease if it's a rental.
And very quickly, because we're running out of time, when is the commission earned?
So the default rule in the state of New York is on the meeting of the minds of substantially all of the essential terms of the transaction. In English, though, because most people write in the contract, and any attorney that's smart will write in the contract, on closing. Keep it simple, stupid.
And that really means on closing.
That's what I would put in the contract if I was an attorney. The broker is going to write on a meeting of the minds, which could be even before contract.
And so that would mean the broker has no recourse if, for one of a million reasons, the contract the property did not close. The
default rule in the state of New York, the broker would have recourse and they would pursue it. An attorney would write on closing, no recourse.
In 1 minute, can you just summarize the ethic guidelines you want to leave real estate brokers with?
I think the most
and agents.
I think the most ethical guideline for brokers, and this is what I've been teaching recently. I have a 5-year-old that graduated kindergarten, and he taught me it. It's called liar, liar, pants on fire. And what that really means is if you just tell the truth to everyone, you have nothing to worry about. When I tell someone I represent you, the seller, and I represent you, the buyer, I'm a liar. I can't represent you both. That's called a conflict of interest. I need you to waive. Liar, liar, pants on fire. Don't be a liar.
And do you have any other comments for consumers in dealing with brokers?
Yeah, great. I think consumers got to realize how hard a broker's job is. You count this number and you say $1 million, $1 million house, they got $60,000. What about the 20 houses that they pitched that they didn't get? What about the 5 houses that they listed that they didn't sell? What about their marketing budget? And by the way, the brokerage firm is taking money, as is that salesperson, as is the other brokerage firm, as is that salesperson. They're really working for a lot. They deserve their money.
And but for their efforts, you may not have a buyer or seller.
But for their marketing dollars, too. So it's efforts and putting an investment in your property.
And also, do you encourage lawyers to be reasonable with brokers and brokers to be reasonable with attorneys? Just in a few seconds.
I encourage everyone, irrespective of field, to be reasonable until you're in front of a judge. Then rip their head off.
Okay, that's the end of our very interesting and informative program with Andrew M. Lieb, and as you've heard, he has all kinds of programs and information on his website, which is Lieb at Law. It's LIEBATLAW. You also can listen to any portion of this or the first part of the program through the podcast at nccradio.org. The code for the Nassau Academy of Law CLE is 102 Lieb. So that's 102 Lieb.
Spelled like
LIEB.
Long Island Education Board.
Okay. And thank you for listening to this program of Law You Should Know on 90.3 WHPC, the voice of Nassau Community College.